Here.
And Councillor Foster.
Here.
Madam Secretary, you have a quorum.
Thank you very much. We do have a quorum. The approval of the agenda, anybody have any problems with it?
I saw no problems. I make a
Okay.
motion that we approve the agenda for the legal meeting today as advertised.
Is there a second? Okay, we have a motion and a second to approve the agenda as presented. Any discussion? Hearing none, all those in favor, please signify by saying aye.
Aye.
Opposed, no. Motion carries. Thank you. The minutes from the July 23rd council or legal committee meeting, we have in front of us a corrected copy of those. So if you will notice, primarily the difference from what was published is the fact that Councillor Perry was joining us via GoToMeeting. And, oh, this is funny, nothing. And just a couple other words adding qualifying in a couple places. So if we can look at the amended minutes as what we're voting on today.
Madam Chair, I make a motion that we approve the amended minutes of the July 23rd of 2020 meeting of the legal committee.
Second? Great, we have a motion and a second. Any further discussion? Hearing none, all those in favor of approving these minutes, please signify by saying aye.
Aye.
Opposed, no. Motion carries. Good. So, the first item on our agenda is our Roswell Air Center lease. Mr. Stark?
Afternoon, councilors. What you have before you is a renewal lease for John Berry and Dixie Lee Wagner of a space in Hangar 91, space D. It would be for a one-year renewal. The monthly rent amount is $849. The annual rent amount would be $10,188.
Okay, thank you. Let me just say, I for one at least appreciate getting just, the facts, the information on the lease, the first page, appreciate that. And then we have attached an Exhibit A, which shows us where this hangar is. And then the next exhibit is just a bigger version, right?
Yeah, we seem to be wrestling over maps sometimes, so better if we can get it in here this way.
I just,
Okay.
I don't know if that's an exhibit. I just included that because there was, in the past, questions about where is this actually
Exactly.
located. So I just put a copy of the map
Okay.
in the packet so you could see where it was.
And I
Perfect.
appreciate it very much.
Great, okay.
Madam-
So, go ahead, please.
Madam Chair, I make a motion. Are you ready for a motion?
Sure.
I make a motion that we send to full council on consent agenda approval, recommendation of approval of lease agreement with John Berry, Dixie Lee, Wagner, and Cliff Wade on building number 91, space D, 4,589 square feet, more or less. The term being 1 year commencing October the 1st, 2020, and ending September the 30th of 2021. The regular amount of $349 a month, $849 monthly, $10,188 annually, subject to all other terms and conditions of the lease.
Do I have a second? You have a second to send this to full council with a recommendation to approve. Any further discussion, comments, or questions? Hearing none, all in favor of the motion, then please signify by saying aye.
Aye.
Opposed, no. Motion carries. It will go to full council. Thank you.
Thank you.
Sorry, you're going to have to stay around a little bit. Next on the agenda is an ordinance revising Chapter 16, which is nuisances, and Chapter 8, camping and campgrounds of Roswell City Code. This has been through public safety with a recommendation for council to approve, but all ordinances are supposed to go to through legal, so here we are. Bill Morris has worked incredibly hard on this, and I know it's been frustrating, so forgive me. Let me just tell you before we get into this, because I want you to talk, but as you look at the red line copy of the ordinance, you'll see the yellow text is everything that public safety approved. And
Correct.
then Parker and I got together and tried to do a little wordsmithing, cleaning up, logical placing of things. So that's the red line part. So, Bill, if you will give us your,
And first, we really do thank you for, having the comments ahead of time so we can incorporate them into this document, so we just look at them straight off. This is a redo of the code enforcement's primary document, Chapter 16. Last time it was really modified, I believe, was like 1984. A lot of the components were there then. Some stuff just didn't make any sense to us. I mean, we didn't even know what it meant, but it was time. And so what we want to do is update it. So we started with Chapter 16. We noticed we needed to go to Chapter 8 in order to kind of make things more clear. We're going to separate Chapter 8 amendments in the final with one ordinance, and then Chapter 16 stuff in another. Hopefully we'll get the numbers together, but because they are interrelated. So beginning really on page, all of it really starts on page 10 of the packet. And we just added a few things, and a lot of this came out of the code enforcement officers who've got 20 years of experience and have come across a lot of these situations, and so we gave them a lot of latitude on this stuff. The one that really starts is weeds and tall grass on the next page. And you can see, basically it's things that are bad with tall weeds and grasses, trying to make sure people keep them down. That's actually something that occupies a lot of our time, our officers' time, taking care of offending properties with that.
yes, Counselor Perry.
And now,
What's better for you?
for me, it'd be right now, it's,
Okay, yes, go ahead. I don't believe we do.
I would have to check, but I can make sure that we do prior to. Mhm. Okay, back on page 11, any basic questions? A lot of this was an attempt to kind of collapse a lot of the language, take out redundant stuff. And so
Madam
we're-
Chair,
Yes, Counselor Foster.
I have a question on tall grass. That's kind of broad. Pampas grass, which is grown at 6 feet to 8 foot, that's grass. So is that considered tall grass?
It's not considered a weed, it's a decorative plant.
Well, but tall grass isn't a weed either. Tall grass is planted and meant to be there. And so if you have grass that's over a foot tall, pampas grass is over a foot tall. That when we get to this, I understand that that's not what we're meaning, but when we're writing an ordinance doesn't have gray areas. So pampas grass is suddenly not allowed in the city of Roswell, according to this ordinance. You also have buffalo grass, which is a native grass to this area, and some people let it grow to its natural height so that it would, and at that point, it looks like it might not be natural, but it is a tall grass that's over a foot tall. How do we distinguish that in an ordinance? I have a problem. I'm okay with weeds, but when you say tall grass, now we're putting stuff that's supposed to be in our yards, and now we're saying we can't have pampas grass, because that's what this is saying.
Madam Chair, would it be appropriate to to consider at some point, don't know that we can fix it in here right now, but to consider either changing the name of tall grass to grass, and then you define, because I would be thinking that Mr. Morse's intent here is lawns specifically versus the oriental or the decorative. So maybe there's a way of defining that to where the concerns, because I can see that people would question that. Maybe that's something that Mr. Morse can work on and bring back when we take this into full council, just as a note. Does that sound proper?
Okay. We'll look at that. What was the other one, buffalo grass?
Buffalo grass, yes.
And I would note that this
It's
subsection
decorative,
shall not be
yeah.
construed to apply to alfalfa and other agricultural crops. I don't know if alfalfa is part of what you're considering grass, so that one's already exempted.
And so is corn. And so, but there again, I mean, when you're talking about weeds, most people understand weeds are things that you do not want, or, but another person's weeds is another person's flowers, just going back to the junk. So, it just depends on if it's purposely planted to be at that height. And I understand what we're trying to get, but since it's an ordinance, we need to be very specific.
Madam Chair, may I just ask, just between the attorney and Mr. Morris, it does say farm or garden produce or other cultivative products. Cultivative would be dealing with
Planted intentionally.
planted intentionally, so maybe there's a way to just put that within that section as in defining, and then that would, I don't know.
I think we can fix that. With
Only
the
problem
difference.
is my lawn is purposely planted. Now, my lawn may not supposed to be over a foot tall, but still, my lawn is purposely planted too. So that's what they're just trying to say, and I don't know how you regulate that. And that's where I understand why we have weeds and such, but now we're trying to say the height of your lawn is supposed to be a certain height. And that's where I'm getting to a point where I think we might be trying to regulate too much. Thanks.
I think that maybe if you just add like decorative grass in there, would be fine.
Okay. We'll come back with something.
Good.
Like city council.
Okay.
We
Thank
got the
you.
gist.
Thank you all.
All right. Moving on to page 12. Just kind of a general statement about unsanitary and hazardous premises. Basically that, and the ones that we added were all properties must have a valid solid waste service contract, which also says that they also have utilities, water, sewer, and solid waste. All outdoor storage of materials on display for direct sale or rental to the consumer shall be enclosed and screened from adjacent streets and properties by placing a solid wall or fence made of brick, masonry, wall, stone, or wood on the property line, no less than 6 feet in height, or the height of the materials being screened, whichever is greater. That is actually directly out of the zoning code. That's one of those that's a crossover. That's one of the things that we've always talked about, is that we got two chapters. They kind of touch each other, two documents that kind of touch each other. One day, probably should try to bring them all together. It would be nicer, easier. On to the next page.
Question.
Yes, sir.
On D, it says all properties must have a valid solid waste service account. Why did the other committee want that in there?
Because that means that they basically have minimum standards of service with the utilities. You can't have the solid waste without having the water and sewer. So the property, basically they're saying it's unsanitary or hazardous to be in a place that doesn't have water, sewer, or solid waste. It's a general statement. It's all it's saying.
It's not meant for like rental, or like if somebody owns property or something?
No, if they don't need to have it, it's fine. It only talks about the premises.
Thanks.
That's all it's intended.
Madam Chair. my problem with it is all properties must have a valid solid waste service account. If you, you own a vacant lot in town, you don't have a water meter hooked up, you don't have a, so now what are we saying that they have to have one? Because it says all properties.
It also
All
says-
inhabited properties, all, I mean, my problem with it is if you have, all properties is all properties.
And I will say that this kind of came up in our discussion last time when we were looking at the solid waste ordinance, and by statute, we do have the ability or the right to charge all properties, whether they use the service or not, for sanitation solid waste fees. So that is something we can do. And right now, I think as the solid waste ordinance is written, it is written, every property owner shall be responsible. So this, as it's written here, appears to be consistent with what we did last month.
Yeah, well, and it may be something we have to change, because I don't see that, property sitting vacant. I mean, and how do we charge that? We've got people that own 50 acres in the city limits that have no that have no water service. Now, do they get the same charge as someone that has a single family occupancy? I mean, if we made the mistake on the one previous, we may need to go back and change it, but I don't see how we can't, I mean, and here again, it's an ordinance, and so when we say something, we're codifying it that,
I think we could take care of that by putting all developed properties.
yeah, and that works for me. All developed properties, all inhabited well, even developed properties, because it may not be, maybe an empty building, but it still needs to have.
That would take care of what the basic problem is. It's on those that would, and it does start, I mean, the section does state it's about premises,
Right.
so it's developed. So if we're okay with that?
Yeah.
Okay, cool.
Okay. Thank you all. Go ahead, Bill.
Going over, I'm sorry, did you say something? I missed it.
No,
Oh,
I said, okay, Bill.
Page 13, that one section was kind of redundant with the previous section, the one at the very top there, about refrigerators and containers and stuff. Need to just make sure that no kid gets caught in. This next section, 6.8, we're really not sure. It was interesting, because it basically would have prohibited cesspools within in the city. Well, that's already something that is taken care of. The erecting of a carbon black plant closer than 5 miles from the corporate limits without written consent of the governing body. That was strange, because the ETZ is one that would actually have authority for that. There's another one about the slaughterhouses, spitting on the buildings. We just thought it was just kind of like, this is antiquated stuff, so we just said, need to get rid of it. That was our thought. But next is the section that's probably the most important for code enforcement right now, and it has to do with the removal of nuisances on public properties. And this is things that have popped up, particularly with homeless situations, tents, and illegal structures that have shown up in arroyos. How do we do this legally? And this thing, this next section here that goes on for about 3 pages, Parker did a masterful job of taking an original document from the city of Honolulu, and which dealt with this and has been federally challenged and basically validated. It was like 12 pages long, and brought it down to three pages. So, but basically it talks about how to do this, and it really depends on notice, giving the property owner, not the property owner, the what am I looking for? The nuisance owner.
Yeah, I guess.
A notice that we're going to come and get their stuff if they don't take it away. Then it has to have a list of information that's available to the owner about where it's going and when it was taken and what they need to do to get it back if they want it. There's also information on how long we have to impound their materials And in the end, if it is deemed to be dangerous, we don't have to do that. We can just get rid of it if it's known to be bad. And this can include needles and other things and all sorts of bad stuff. So we spent a lot of time on this, and basically it's a series. We're going to have to do a little bit more work because we have to monitor and notice and keep track of dates and all this good stuff. But it can be federally. It would survive a court challenge, is our opinion, and so that's important to us. Why go through all the trouble and have it all basically kicked out? So that's basically the intent. Do I have anything? You want to add anything to it?
No, you got it.
Okay,
You
this
guys
is,
meant to
like
go
you say,
through it,
all
any-
a lot of new material. Any questions or comments? Okay.
So that's the intent, and that was a really important part. We've had difficulties in the past with these things, and some of the structures that we're talking about are actually quite elaborate for an illegal structure made with pallets and other things. But anyway, going on to the next changes are on page 21. At the bottom, 611, noise generally. We wanted to add excessive use of a generator in a residential area after daylight hours. And the intent here is somebody that's just, for whatever reason, has a non-emergency kind of event that they just want to have a generator going for, because they're pretty annoying, and somebody's trying to sleep. Also, we wanted to add a little bit more clarity with sporting events. We added as an exception to the noise ordinance, one event per month and no later than 11 p.m. So we added some criteria there. It was kind of open-ended. We didn't know how many or how late or what's the exception for. We added some criteria. Sure.
On the sporting events, on the east side of Roswell, there's a guy that has like a mud bog or something. I don't know what he does with it, but he makes a lot of noise.
Mhm.
With this, a sporting event, is that considered a sporting event? Or is this just like for football,
No,
baseball?
I tell you, I have something called the Planner's Dictionary, and like 3/4 of them, all those definitions say that almost in the first breath, racetracks are a sporting event. Ask a NASCAR guy. It's a sporting event. And so it's in there. Without any kind of limitation, though, they can argue that they can stay open. And we've talked to these guys. They've been trying to be better neighbors here recently. We've gotten through, and so we're hoping that this is just kind of the teething time. But this is just to try to provide additional criteria for noise events. It can apply to sporting events or this kind of thing too. So
And that gentleman, does he have a business license?
oh yeah.
Are you referring to something different, Councillor Peterson?
There's a place on Atkinson.
There's a racetrack,
What's it called?
Alien Racetrack.
Is that the same thing?
That's
Out
the
at-
one I think you're talking
Out
about.
at the Air Center?
Oh, no, this one is,
This is off of Atkinson, dirt track.
it's a dirt track,
Yeah.
fully
that-
licensed.
Does that guy have a license over there?
Yes, sir. He has an approval from Planning and Zoning Commission as well that allowed him to do that, and they've complied with all the criteria. There's just been a few problems with events going past the 10 o'clock thing. So we just wanted more criteria in here so it doesn't become an issue.
Well, I would like to see that the 11 PM, even earlier than that. Because, most people are, they have to get up in the morning and go work. They don't want to sit there and, listen to.
Except for the hours are already to 10 o'clock, so if you say you take it down to 10, you don't need an exemption because that's within the criteria to begin with. And it will only be one time a month.
All right.
Madam Chair, Mr. Morris, when are they usually having these races? What days of the week?
Friday and Saturday nights.
Okay, yeah.
They have been trying to get done by 9:30, but it just takes one wreck, one turnover where they have to pull the, cars off the tracks. It sets the timetable back. And also it rains, when it rains.
Because, those race cars out there, they put a lot of noise out.
When they've also installed their mufflers, they put their mufflers back on for these
they?
events. And they've been trying to work with us, and we've worked, trying to make sure that we understand that it can get loud, but it's important that the noise stops at a certain time.
Okay.
We think we have it somewhat under control.
Thanks.
Madam Chair, if I could, I think that's going to be hard to regulate anything past what we already have. I know that when we're not having the problem right now because schools doesn't have football, but during football season, the Wool Bowl, as far away as I live from the Wool Bowl, I can hear it to significant hours way late at night. Sometimes those games, though, shouldn't last as long as you'd think. You can go into overtime and have the high school bands and all of the sounding off from that. So I think it's going to be very difficult to regulate past what we already have. Just a thought.
And in some of the events, like when Old Municipal Airport does build out, there'll be homes that are much closer to those kind of events, and they'll be experiencing the same kind of events and noise. So, it's just something that's in there.
Okay,
We okay?
okay, thank you. Go ahead.
On back, let's see, top of 22, they also wanted to add block parties approved by the police department, Roswell Police Department. There are neighborhoods that actually like each other and will actually request to be able to close off a road. It's with the approval of the police. They have an event, so that would also be allowed to go past 11 o'clock, since it's those people anyway. Going down,
You may, I'm sorry, Madam Chair, you may also consider on number 4, I don't know, I know that when we have blocked off before for different events, it was police and fire.
Police and fire.
So I think that would be good to add into there. I think for stuff like that in the past, it's been police, fire, and I believe zoning as well, or engineering, someone, so that the streets department, so they understood, but at least those two.
Concurrence with Ms. Jennings just now, it should go through the set committee, which means, because for special events, this type of function is listed there. And I don't know, because I slept since then, do you mind telling us what all is involved in that? I think it more.
Madam Chair and committee members, we have an internal committee that reviews any special events. I believe block parties are included, but whenever there is a request for a block party, we make sure that police, fire, and streets are aware of it, specifically police and fire for any emergency traffic or situations that would come up. They are notified of that road closure. So I'd make the recommendation that it is included in that process.
and it might just be easier because, changing how her organization, was formed, it may reform later some other way, to say approved by the city. A city-approved block party.
Okay. Does
So whatever
everyone
the
agree with that? Block parties approved by the city? Okay, great.
Approved or permitted, because that may be a better word
Okay.
to use.
Okay.
Permitted.
Permitted by the city instead of approved by, okay. Permitted by the city, great.
All right, the next section down is more of a change out from the people that are actually supposed to be doing it. You'll see a bunch of them, city attorney struck out, replaced by city manager. It kind of goes on all the way down. Code enforcement, because the process wasn't, this isn't our process now. So it's changed a little bit who goes in front of who now. So this better it is what we do. So we just changed out all the the names of the responsible parties. And that kind of goes on to the next page. And if everybody's okay, going on to page 26. We just struck out the word private under authorized receptacle for litter storage and collection. We don't have any. We just deal with the public. Going on page 28. Just want to put in something about not blowing all your leaves out and clippings out into the street. Coming on down, and litter in under 16-24, we added areas not to litter or flood control and storm drainage areas or other bodies of water. Try to flesh out the whole list of water bodies that we may have here, because garbage can block up flumes and exits, cause flooding. Moving on down, this is another area that we wanted to discuss, and it was with vehicles. Actually, we spent a lot of time on vehicles. And this has to do with, right now, basically inoperable vehicles. Sure.
Excuse me, Counselor, can you speak to into your mic, please?
I thought it was on, that's my fault.
Thank you.
I can be wrong once today, so no, it's been more than once, I promise you that. I'm sorry, let me start over, so if anyone is watching, and for the record, people will be able to hear. On page number 29 of the agenda, section 16-27, distribution of handbills on posted premises. If you could just help me to understand what we have there.
Now, this is the idea here is to try to minimize handbills that get tossed around in the wind, that just get stuck in doors, door handles. Just trying to cut down on the litter. People will put these under, the windshield wipers, parking lot, like Albertsons and others. First thing most people do is just take them out and throw them on the ground. So they just blows around.
So is this only on areas that say no trespassing or no peddlers or agents, no advertising or similar notice, or is this on any private property at all?
All right.
Which one?
It would be under, let me go back.
I'm seeing on the first part, no person shall throw, deposit, or distribute any commercial or non-commercial handbill upon or to any private premises if required by anyone thereon not to do so, or if there is placed on said premises in a conspicuous position near the entrance thereof a sign bearing the words no trespassing, no peddlers, agents, or agents, no advertisement or any such notice indicating in any manner that the occupants of said premises do not desire to be molested or have the right of privacy distributed or to have any such handbills left. I just want to make sure I understand at the very beginning as it starts, it looks as if it's to any private premises, but I just need to make sure that I understand that it's any private premises that is posted.
Correct. It's the
Okay.
posting part.
Yeah.
All right.
It is posted.
I just
Yes.
want to make sure that that's the clear
Right.
intent. All right, thank you, sorry.
No? Okay. One of the issues that, as I said, has to do with vehicles, inoperable vehicles. And an inoperable vehicle basically is one that can start up and you can move, drive around. It doesn't have to be registered and it doesn't have to have insurance. We have vehicles that can start and can move, but you can't take them off your property because they're not registered and they're not insured. And so Public Safety Committee wanted to have that language in there that would require having, vehicles basically have to have registration and insurance in order to be considered operable. Now, there's one person, there was some talk that, well, what if I have a bunch of vehicles? We do have means to allow for vehicles that are not operable to be located elsewhere on property. But this was something that they felt that would really help them in certain situations. We're trying to clean up. We have places which have vehicles basically around the block. They own properties, and none of them have tags. They're just parked bumper to bumper, all the way around on their property, and in some cases, even in the right-of-way. And so the idea here is to say, okay, if you want all these, and you've got them, they have to be registered.
Madam Chairman, if I may ask, how are other municipalities? I know that other municipalities have found creative ways to deal with this. Is this the way they have chosen to deal with it, or are we doing something that's maybe different than other municipalities through this?
I've been in one municipality that did require this. And it was because there's no parking, and that place was packed with a lot of cars. So if somebody wasn't using a car, they're taking up spaces for other cars. And so it was a problem. So if you're going to use a car, let it be one that was mobile and operable and legal to take out onto the roadway. And that was the key. An operable vehicle is one that you can actually take on the road and drive, not just start up and drive around on your own property.
Madam
Go
Chair.
ahead, Councillor Foster.
So what we're saying, and see, and with this, when you keep reading it, some of these sentences are written by C.S. Lewis because there's a period every paragraph or so. But say I own a vehicle parked in my driveway, but it has to be registered.
That's the intent.
I can't be okay with that. So now we're saying people can't own things.
Well, and now
We're
that's-
dealing, I think that we're violating their rights. Me owning a car in my driveway does not affect any.
There's one other part to that.
Yeah.
After that, it's between the property line or a curb and the sidewalk, or between the curb and the lateral line of the roadway.
We say that, but like I said, this sentence is so long. Upon any private property or between, it doesn't say, and, it says or. So that means on any property. So that does not mean, it means I can have it so far out of the way that no one can see it, but I can't have a vehicle on my property that's not licensed and registered. And so, that's beyond the scope of our ability, because that's actually violating rights.
Do you have suggested language?
On the roadway, I understand that. If
Sure.
it's parked on a public roadway, it has to be registered and insured. But other than that, I mean, and I understand the problem. I know we have lots of places that we have people park 5 cars in their front yard, and none of them are running. But that, it gets to a point where, at what point do we have a right to tell people what they can own and what they can't?
Councillor, let me do a run-through on that and look for, at the time for at the public hearing.
And at this point too, the way this is written, I mean, I rent a warehouse where I have 3 non-running vehicles that's off property, but it's still private property, and according to the way I read this, it would still be illegal. There's probably 50 cars on that commercial property right now that aren't running, that are owned by other people. This is saying that they can't do that. And I mean, it may not be our intent, but there again, this is an ordinance, and we have to be very careful about our wording.
Madam
So,
Chair, I'm sorry.
My turn.
I got it.
So, Counselor Foster, is it that they must be registered and licensed and have insurance is the concern? Or
Yes,
is it
I
the
mean-
whole idea of where they can be abandoned and vehicles can basically be parked? I'm sorry.
Well, so what you're saying is that every vehicle you own has to be licensed and registered, even if it's a vehicle that you're not intending on ever getting to that stage again where it's drivable. I mean, if you're keeping your dad's or your grandfather's truck that you know, and now we're saying you can't do that.
Well, there are exceptions if you get down on B2, but I'd rather, let me take a shot at it. I think I understand what the concern is. If the concern is, if I can get a consensus here, is there a problem with having, if it's in the city's right-of-way, the right-of-way, not just the street, the right-of-way? Can we require business license and insurance? Or, I'm sorry, registration and insurance in the right-of-way?
Can I back up even further and ask, is it legal to park in the right-of-way anyway?
They do, yes.
Is it legal?
Sure.
I mean, I thought the right-of-way was just what it says. It's a right of, passage or
There-
whatever, not a right of
If
passage.
I can recall, we have our uniform traffic ordinance, which discusses a lot of that kind of stuff. And if I can recall, our traffic ordinances, they say that you can park in the right of way as long as you do not obstruct the traffic.
Sidewalks as well.
So if and I mean, this is kind of one of those things that in my experience is honored in the breach in this town. I mean, everybody parks right on the side, and a lot of times when two cars are coming, one has to stop and wait for the other one because you parked it on both sides and there's only room enough for one car. That's not allowed. But everybody
That's
does
on the
it,
street.
so I don't
That's on
know.
the street, that's not on the,
That's true, in the
Well-
city's right of way.
And there are a lot of people that park, if they have a sidewalk that's further in on the property and from the curb, they'll park parallel or even perpendicular in some places that have that kind of right-of-way size. So my question is it in the right-of-way? Or is it, would you consider the insurance and registration?
okay, so that's the question.
And we'll look at the private, I mean, I can understand that one.
And I think that in the right of way and on the street, they need to be licensed and registered. They need to be movable. They need to be, I mean, because that's true. I mean, if we're having to go in to work on a water line, we don't need to tow away a vehicle. It needs to be where we can get to it. And so I understand that. And that's where my major thing is, if someone has their uncle's 57 Chevy and it's just parked in their driveway, and their driveway could be like mine, a semi can park in my driveway, and it's way out of the way, and we're saying they can't do that. And so, and I know it's not the intent, but that's what we're saying.
Well, and understand currently what it says is that the vehicle, forget about the insurance and registration, if it appears to be dismantled, abandoned, wrecked, inoperable, or partially dismantled already on private property, it can be considered an inoperable vehicle right now.
Right.
What this act, it says, if you're on private property and it looks like it's a junk car, not that you're working on it, not you're doing anything to it, I know, and we all know those cars that are just sitting there and haven't moved since you moved into your house. That's what we're talking about currently. That's currently in the code.
Well, and I don't really care if it's currently or not. I think it's a violation of our rights. That's what I'm saying. And I'm saying, and would be willing to go to court for that one. If it's dismantled and it's not been worked on, then it's a junk car. But I'm just saying a vehicle that's sitting there and hasn't moved for 10 years isn't a junk car. It could, it's just there.
Let's get comments from Councilor Perry and Peterson on this issue. Okay. Councilor
So
Peterson.
first, he's been waiting.
I had a question right now is, can people have a vehicle that they're working on in their backyard in a fenced-in area with, you know,
Mhm.
and they can?
Out of view.
They
Yeah.
can do that?
Yes, sir.
Okay. Because I've had a lot of complaints, one of the new enforcement guys going around and he's telling people, this is a junk car, you gotta get it out of here. And he's running, he's telling these people they need to get rid of their vehicles. And if we approve this, you know, that's gonna lead to these enforcement guys. They're gonna go wild and they're gonna go after people that maybe not, you might not think they won't do it, but these, I know a few of them. I'm not in favor of this vehicle registration insurance at all. I have many vehicles and they run, and it would cost me a lot of money to put insurance and, you know, registration on them. Thank you.
Okay, Councilor Perry?
Madam Chair, if I may say, I think that we're sort of getting crossed in a couple of different things. I think that, I don't think that code enforcement is looking to run around and you've got cars in a driveway and they're watching and watching and watching. I understand what Councilor Foster's saying, the way it's written now, yes, it could be the case. So we do need to look at the language, but I think the intent that we need to build the language around is that we're trying for the safety and welfare of a community, is keep from having 5, 6, 7, 8 cars just piled around the house that's just sitting there. You can't mow around them, you can't get around it, those kind of things. I know I have lived in cities in the past, and I brought it up several times and wondering about, they don't allow parking on non-permitted surfaces. The permitted surfaces could be concrete, it could be asphalt, it could be crushed rock. But grass and lawns were not considered for several reasons proper. I know I lived in a city and did not know the code at the time, and had a car parked underneath a tree, and I was required to put crushed rock there and to make it compatible as a surface to park on. I don't know if that is a amenable way to look at that as well, that may fix a lot of the problems that you're looking at. I don't know, but that's just a thought.
Okay.
Can I just add a thought here?
Please.
So just to put this all in context, the section 2 there, the provisions of this section shall not apply to A, any vehicle within an enclosed area and out of public view on private property. So that doesn't address the vehicles parked in your driveway, but it is, as Mr. Morris alluded to, you can have a vehicle that you're working on in your backyard that's behind your fence. That's not going to have to be registered and insured, as I'm reading this.
That's correct.
So, is the real question now to some of the revision in section 1635-1? Is it the revision language or some of the original language that we're looking at?
It would probably be to accommodate anything in the right-of-way, to protect the right-of-way. That's clearly that's one part of this thing that we have an
Right.
issue with cars that are dismantled, inoperable in the right-of-way. I think that's one issue. The second is about the current state of this text without that provision, which says that even if the vehicle looks like it's, as it says right now, abandoned, wrecked, dismantled, inoperative, or partially dismantled, that on private property is considered an inoperable vehicle right now in this section. So really there are two sections. Maybe we try to break it out. We'll get more descriptive and give it a shot. So those are the two instances, on private property and then in the right-of-way. and I think we can describe both.
So you would break one out into A and B?
Yes, and yes, there'd be an A and a B. So if you've got, so we can describe things that are out in the right-of-way would require a fully operational vehicle. On public property, we just leave the language as it is and take those yellow streaks out of there. So that's currently there for private property, and then enhance the requirements for cars in the right-of-way.
All right. Is everybody okay with that? Okay, okay. Okay, let's do that, Bill, thank you. You know, I just noticed this, just above that, above Article 3, it's SECS, it should just be SEC.
It should work.
16 dash, I'm right above Article 3, where it says SECS 16-34. It should be SEC, the S doesn't need to be there, it's only one section.
Oh, okay.
Very minor. Okay. Continue, please.
All right, since this was brought up more by the planners and engineer, it's a situation that we've seen, it's on page 31, where we've talked about the number of cars that are starting to show up in various properties are kind of overloading the on-site parking spaces that were intended to support that house. And so more cars are getting parked out in front. And there was a little bit of a concern about how, and I've got examples in my neighborhood, where cars, you can put about 3 cars in front of a typical house between the edge of the driveway and the property line, and it's tight. And then the neighbor has the same 3 cars. And so the idea is can we create a slight buffer so when you're trying to pull out of your driveway and you've got cars on both sides, you don't have any kind of visibility, or it's really limited. And it's also limited for the driver that's coming down those streets that are having all those cars, because it's harder to see where the ends of those driveways are, because it's just car. And so we're asking for a 5-foot, just a buffer space between the end of the apron back, just so you got a little bit of separation, so you can kind of see around. It's more of a safety thing. And also making sure that the drop-down ramps, which is the figure, the second ramp, or the second figure there, where a car isn't parked all the way in front of those ramps. They have to clear those ramps and have a little bit of space, because again, people in handicapped in a wheelchair coming down, just trying to get around some of the sidewalks, it's dangerous with all the cars that are out there. So we just like a little bit of a buffer space between, from the aprons. And again, we're not looking to try to go after something. We're just trying to allow for a better and safer situation.
Madam Chair,
Yes, sir.
can I just ask, is this not already covered under traffic code somewhere? I know that when I was counselor for Ward 4, and Councillor Foster will be familiar with this because he worked with me on this, there was a lot of problems with the basketball games at Roswell High School, so those streets that are just to the west of South Lee Avenue in that same block were having significant problems, and Councillor Foster and I got together with the police department and everything, and they ended up going out there and actually ticketing people because they were too close to the entrances of the ¿cómo se dice? I'm trying to think how you say it in English, the driveway. So I remember that specifically, so I don't know if that is already covered under traffic. I don't know if it's in traffic or where it could be, but my other question would be, I'm not saying I'm against this, I think that there is a safety issue, but does it belong under Article 3, storage of abandoned, wrecked, dismantled, or inoperative motor vehicles? because section 1636 is under Article 3.
Correct.
So if it needs to be in a place, and I'm just asking, does this go in, which I believe it does it go, is its proper place in nuisance or in inoperable vehicles? So I'm not disagreeing with you.
No, I understand.
I'm disagreeing with its placement in this ordinance. And I yield.
Councillor Peterson.
I agree with the handicap ramp, but if you do this to people, that's gonna make a mess. You eliminate a lot of my parking at my house if you do this. And I have a fire hydrant on one end. I can't park that close to it. So with this right here, I would have like 2 feet of parking in front of my house. And I will not support this at all.
Madam Chair? And I agree with Councilor Perry that I think this falls probably under a different section. And I do think that it's probably already in our parking code for the sidewalk, for the corner. I'm not sure you're allowed to park that close to a corner.
I'm going to check on that. It went
Because-
through public safety. Nobody brought up that at that time. I know this is for the permitting that, basically Lewis would do. But I will check on that. If it's already there, then I'll strike it.
Because I think that would block the sight triangle of someone pulling out.
That's the intent. It's not-
And so I think that it should already be codified as far as that. And I agree with Councilor Peterson on the driveway. In fact, there have been times where I parked in front of my driveway and blocked my own driveway, and I knew it was against our law, our code, but it's like, well, I'm blocking myself. I can't really, I could see someone coming and trying to give me a ticket for blocking my own driveway. But there are times when you have to, and I agree if I was blocking someone else's driveway that it should be a ticketable offense, but when you're blocking yourself in, and this is what we're pretty much saying is we're not allowing this parking on the edges of our own vehicles, and so I agree with Councilor Peterson that we have enough ordinances as it is. We don't need to add to some of it. So,
Madam
thank
Chair,
you.
one other thing, if I may want to check as well. It seems like, and I just may be just running through my mind other cities, but it seems like there was something as well with not parking across from someone's existing driveway opening. There was something about that because their ability to back up safely and get out of their premises. So I think it was in that section, but I may be wrong. May just deem some evaluation, and we may find it somewhere else.
Thank you.
Okay, look at that further. Any other comments? Okay, let's go ahead then to the next page. Bill, please.
Yes, this is things that are related to for the towing of vehicles. Basically, these are their requirements. These are state requirements for towing companies. We don't need to have them in there. We don't tow. They do. They just have to follow state regs, so we just wanted to strike that out. And that applies to all those pages there, those 2 pages, 32 and 33.
So, I'm looking at above the strikeouts, bless you, on page 32, we've got section 41 and through 43 reserved, and then in the middle of the next page, 45 through 60 reserved, which gives like 19 sections reserved. Is that necessary?
It just kept, that way I don't have to change the number on that one section there, that one paragraph.
But we're taking, if we take them out, we're reserving section 16-41 through 16-60.
1641 through 43. And that takes care of the
Oh,
two that
okay.
we
And
deleted.
then
or
you've
the
got
three.
44, which you would move up to 41.
Well, yeah. We'll look at the numbering here.
Would you, I mean, I just don't know if you need 16 reserve members.
Sometimes I do. Future. It's when you need one, you don't have one, that gets me a
I know
pain.
you don't have it when you need it. Okay.
All right. The next section is the chronic nuisances that we passed a year or two ago. And moving on to page 36. It was requested that the sunset provision be struck, since we just got through our first one. The ordinance that adopted the nuisance properties contained a sunset clause of next year, or in 2 years. And so you can take that out at any time as city council. So they just said, why don't we just leave it out, and if you don't want it, we'll take this section out later. So that's a recommendation.
Madam Chair, may I just ask
Yes.
why it's an unusual to see a sunset in like this towards ordinance? What was the intent of council in putting that sunset there?
I believe it was put there because we weren't too sure we were gonna be able to use the nuisance ordinance to the way that, correctly, and we weren't too sure how well it would work. And so, I think we had it there just so that we could, I mean, not that the city council can't come back and change an ordinance upon, going through the direct way of doing it anytime. But, I think it was purposely there just because it was a unique way of treating, and classifying nuisance properties. And I think we put it in there just because we wanted to make sure that it was needed. And I think the last two properties that we had that came through showed that it was, and it can be. I'm not sure that we need to remove it this soon, but I mean, I'm not opposed to removing it because I know we can put it back anytime we want to or get rid of it anytime we want to also, so. But
Thank you for that explanation. I wasn't around when it was done either, so. So basically, it's saying this article, which is the whole article for chronic nuisance, shall expire, sunset, unless extended by a separate ordinance?
Correct. Well, it was written that way into the ordinance. So when it got
I-
carried over,
I
it
see.
ended up into
In
this.
a
and-
different, okay.
And that's
I
why it's so
got it.
weird.
Thank you. I'm just wondering if you can, not legally, but can you actually do that? It's got a sunset clause on it, and just take it out? I don't know. Parker, what do you think?
Yeah, I think you can do that. I mean, in a sense, you have to be able to do that because otherwise it would be a past council binding a future council, which can't happen. So you always have the option to change an ordinance.
So it can expire? It can be sunsetted?
Yeah, so it's pretty common to see those, and you see them all the time in legislation
I
that
know.
they'll have, we only want this to last for X number of years. Basically, it forces you to, re-up. Yeah, you have to basically go back and say, yes, we did like this and we want it again. Have an explicit discussion about it rather than let things ride on the books that nobody cares about or is using.
I get that, but, so actually crossing this out, deleting section 16-67, in effect would extend it.
It would go in perpetuity until otherwise eliminated.
Until otherwise changed, yeah. So that is what we're if we recommend deleting this part, in effect, we're answering what it says, and that is, by a different ordinance, we're extending it.
Early.
Right. Yes. Okay. Councillor Peterson.
That was put in because of some counselors, you know, they wanted to see an end of it. That's why that was put in there. I think we should leave it in there unless we get a consensus from the other counselors.
Leave the provision in or leave the striking of it?
Leave it in there. Don't strike it.
Any other comments? Okay, so the question is, do we strike it as it's presented to us today, or do we leave it alone?
Madam Chair, huh?
No. No. What are we striking?
Well, Madam Chair, it's going to full council. Full council's going to make the final decision. I have no problem leaving it as it is. I may make the amendment then. I don't know.
Certainly
After I've
it
studied
can't
it more, but surely I don't have a problem with as presented.
Okay,
I do have a question on the next portion.
so we're leaving that in as a stricken recommendation. Okay, let's move to Section 2, Modification of Chapter 8. This is what you were referring to earlier.
Correct.
Bill?
This one would be broken off into a separate ordinance. So we got Chapter 16 ordinance and a Chapter 8 ordinance.
So what would go to council would be two different items.
So, Madam Chair, it would need, us sending it to full council would be, I would say would need two separate motions.
That's fine. I think you're right.
I would agree.
So, if we go ahead and do a motion on what we've heard of already, we in essence are putting Chapter 8 in a different ordinance. Okay, so do I have a motion on a recommendation to full council on, it would be on an ordinance modifying Chapter 16 nuisances? Do I-
And it's for advertisement, correct?
Correct. For
Right,
advertising.
oh, I'm sorry, yes, for advertisement.
Madam Chair, I, for sake of allowing full council the opportunity to look at this and also to give staff the opportunity to make the changes, I'm going to make the motion like this. I make a motion that we send the draft ordinance of the City of Roswell revising Chapter 16 nuisance to full council for consideration of advertising for public hearing, to be sent at recommendation from this council with the concerns being addressed,
That we've addressed this.
Duly noted.
to be changed moving forward.
Do you have a second? Do I have a second? I'm going to
Yes,
second.
well,
I-
my question is, I have a second, but I do have something that, and maybe since we're moving it forward, I need to bring it up, and I feel bad because it's way back in a section that we got all the way out of. And maybe it's the historian in me.
So do we have a motion and second, then we're into?
Yes, I will second,
Okay.
Oh, we did second, okay. And now we're having discussion.
and then discussion. And let me get back to it. What, the full section that we deleted, it had one paragraph on spitting.
I think you're on page 13 of
16
the
and-
packet.
13, yeah,
Of the
13 of the
packet.
package, and it's section 16:8 and paragraph, or section, or paragraph 4. I mean, and the historian in me, the reason why there's this law, a no spitting law, was because of TB, tuberculosis. But now we're sitting in the middle of a pandemic. I'm not sure it behooves the city of Roswell to remove a historic law that still suits us, and it's still pertinent for today's pandemic, that spitting should not be allowed on public. And I understand, historically, we've never had a problem, I mean, we did have a problem, that's why the TV, it was passed during the TV time. But now, I don't know if it's just ironic that we're in a pandemic and we're trying to get rid of a law that probably we shouldn't. And so, I would like to, but we've already made the motion. And
I would friendly amend that we would, as part of our conversation, Mr. Morris, that we would leave section 16-A, conduct of offense to public well-being. It shall be unlawful for any person to commit conduct offensive to public well-being consisting of, and then number 4
Just keep
being
number
moved
4.
up and that paragraph being left.
Okay, I appreciate it,
And that would then also change your numbering on your others, okay? So that would be,
Sorry,
Oh.
should have brought it up at the
Three
time.
numbers.
as a friendly, I'm okay with that.
All right, thank you. Okay.
That's substantive. Nonetheless, it's okay.
Yes, I can accept it. The second.
It's not a
Second.
So Councilor Stubbs has pointed out that it's actually a substitute,
No, it's a
Substance change?
substance change.
substantive change, yes.
Substantive change.
Thank you,
So,
yes.
so how would
Finding
you
the
So
right
like
it's not
adjective.
friendly, it's just an amendment.
So I would make a motion to my original motion that we amend the
Or
original
you could
motion.
withdraw your original motion.
I'll withdraw my
Thank
original
you.
motion,
Let's
and I make a
withdraw that
motion.
And now
Do you
we
have
have
that,
a new
Sharon?
motion.
I withdraw my motion, and I make a motion that we send to full council for consideration of advertisement for the draft of the ordinance from the City of Roswell revising Chapter 16 nuisances and Chapter 8, just Chapter 16, to include the changes that this committee has addressed, and specifically to keep Section 16-8, conduct offensive to public well-being. It shall be unlawful for any person to commit conduct offensive to public well-being consisting of, and then paragraph 4 being moved up under that section, and all other numbering to be identified properly.
Second.
Okay, and I'm assuming by seconding that, you also were okay with the withdrawal of the first motion? Yes. Okay. All right. We have a motion on the floor to send to full council recommendation to hold a public hearing, or advertise and then hold a public hearing for this ordinance on Chapter 16 with the changes that we have discussed today. Any further questions or comments? Okay, hearing none, all those in favor, please signify by saying aye.
Aye.
Opposed, no?
No.
No. Okay, the motion still passes with a vote of 3-1. So now we're back on page 36 of the agenda, which now would make Section 2, does that now become Section 1, modification of Chapter 8, or is it still Section 2?
It'll become Section 1.
Okay. We're talking now about Section 1, modification of Chapter 8, camping and campgrounds, which will have a separate ordinance. So you want to go ahead, Bill, what you've done here?
We just want to enhance some of the language. We've had issues with campsites popping up in town. And so the first one under B, 8-1B, basically says you're not supposed to use tents to basically live in unless we've added, unless first obtaining a variance from the Planning and Zoning Commission, which we did for the Rivers of Life to allow for, in that particular instance, they went to the to Planning and Zoning to get an approval for a certain number of tents as an overflow system within their back.
But may I also say that that's in a solid fenced area that you can't see from the public thoroughfare.
Correct. And that was all the criteria as part of the variance. One of the issues we've had too is a lot of people have been living in recreational vehicles and trailers. Recreational vehicles are particularly, we have them show up in our parking lots and kind of move in, kind of scoot them out there. So basically what we wanted to do with here was to mimic the language, because code enforcement can enforce this, so can our zoning people. So basically that section there is a reference to Article 24 in the zoning code that deals with what you can do with recreational trailers and such. A section about 24-hour notice of violation can result in them being removed, and then sleeping on public benches, sidewalks, bus stops, or the misuse of any public property is prohibited. And one thing that we did want to include, just kind of an overview, is on the next page. It's unlawful for any person to camp within the city, including inside all flood control, drainage areas, or other bodies of water, unless he camps within a campground that has been issued a business registration by the city. And that should sum it up. I stand for any questions on this one.
Okay, thank you. Councillor Peterson.
I got a problem with E, sleeping on public benches, sidewalks, bus stops, etc. Misuse of any public property is prohibited. I don't think anything wrong with, if you sleeping on going through town or something, you're sleeping on the sidewalk. I don't see nothing wrong with that. And it says, or misuse of any public property is prohibited. What was the intent on that one?
To keep people from sleeping on public benches. We have a lot of places in the downtown where the tourists are trying to sit, or people using it, and they bring all their stuff with them and they sleep on the bench and have all sorts of stuff around them. That has an impact on the visual, on what our presentation is to our tourists. These benches are meant to sit in. They're meant to be communal. Maybe not in the COVID age, but they're not meant to be slept in. And they're designed, the bus stop that we just put in by NIMI, there's a bench in there, but it's designed to not be usable to sleep on intentionally, because people are meant to sit on it. So that's the intent there.
Well, I'm fine with the public benches, but, sidewalks,
And the sidewalks are basically for ADA. We don't have the biggest sidewalks. They're not really, they're,
but if a person is, it's midnight or whatever, everybody's home, a guy's just going through town or something, he just wants to get sleep somewhere.
Madam
I mean-
Chair. Councilor Peterson, may I say comment? I apologize. I don't want to cut you off if you weren't done. Okay. I would just say I feel for these people as much as anyone else. We were just up in Denver, Colorado, and it's just heartbreaking seeing what a lot of people are going through. And there are a lot of people who are just down on their luck right now. And I recognize that, fully recognize that. At the same time, I recognize I'm going through the city quite often in the middle of the night, 9:30, 10:30, 11:30 at night, just with what I do in my profession, having to go and see about people. And I have seen people in wheelchairs utilizing our sidewalks at even 10, 11, 12 o'clock at night, and they've got to be able to have that ability. The sidewalk, the purpose of the sidewalk is for commuting, not for sleeping, and I do see that as a concern. I understand that we're dealing with something now that's horrible. I don't know that the best solution is to permit the sleeping or erecting tents or anything as we saw in some other places on the sidewalk. That just a thought.
Thank you. Other comments? Councilor
Well,
Peterson?
I just have a comment. You know, people aren't allowed in the parks after a certain time, or, you know, the cops will get them. You know, you gotta give these people a break. You know,
What's that?
Gotta give these people a break.
Oh.
You know, if a person's in a wheelchair and somebody's laying on the road or in the sidewalk, you know, the person could, you know, make a move. You know, if the guy's if somebody's blocking the sidewalk, you know, ask them to move. You know, I'm sure they would. Thank you.
Any other comments?
I have one.
Go ahead, Councilor Foster.
I still can't, on 8.7, including inside all flood control, drainage areas, or other bodies of water. I'm still trying to picture someone sleeping on a body of water,
These arroyos,
but it's not a body of water.
it's considered a body of water. Flood control has control of these.
Well, but that's a drainage area, so that covers drainage area. Body of water to me is a pond, so we're not gonna allow someone to, I mean, just reading that, it just throws that to me. I mean, and the purpose why we don't want them sleeping in a drainage area is because it can become a body of water fairly quickly. But to me, when I see body of water, I think of a pond or a lake, and so that one just throws me. But other than that, I don't have a problem with this.
Could maybe the word potential go in front of other bodies of water, or potential
Or we could just change it.
bodies of water?
I'm sorry.
Or retention pond area, I mean, or
All
retention area.
floodways.
Bill
Yeah,
will work on it.
all floodways, yeah.
Bill will work on
We'll
it.
take-
Thank you.
Take that.
Okay, any other questions, comments, concerns about the modifications in Chapter 8? Okay, hearing none, do I have a motion on Chapter 8 going to council to advertise and hold a public hearing?
Just, I hate to
Go
do this
ahead.
to you again.
No, you don't. That's okay.
No, I'm understanding all this, but right now, we're in a state with the pandemic. We are allowing trailers and such because of, a lot of our healthcare people come home and they sleep in they go to their trailer and sleep in the trailer instead of going straight to the house and sleeping with their, and exposing their family to, and so, and I know some that go and they change in the trailer and then they go. So I understand this for a permanency, but also under the state of the pandemic that we're in, we're allowing a lot more leniency on some of this. And so I'm still in favor of passing this, but also understanding that in this time of the pandemic that we have some allowances, and we have been using some allowances for trailers.
And if we do cite somebody and they are in a like first responders or something we didn't know about, we back off immediately. If it's something like that, absolutely. So this is meant for the long term.
And that's why I just wanted to say, have that on record, that this isn't something that we're against us dealing with the pandemic. We are for that, help people using it in those terms.
Okay,
So.
thank you.
I make a motion to go ahead and send to full council modifications for Section 1, modifications of Chapter 8, camping and campgrounds, to be placed on the September full city council agenda.
To advertise for a public.
Advertise
In
for,
October.
to advertise for public ordinance change.
Second.
Gotcha. And a second. Okay. Any further discussion on Chapter 8, camping and campgrounds? Hearing none, all in favor of sending this to full council to advertise and then hold a public hearing, please signify by saying yes, or yay. Yay.
Aye.
Aye.
yay.
Aye, yay, yay.
Yes.
Aye. Those opposed say no.
No.
Okay, then this still will go to council with a vote of 3-1. Bill, your next couple pages in here are from the zoning code and they're for information only.
Correct.
So appreciate that.
Yeah.
So this is not part of anything we'll be
It's a reference, so you guys can read
changing.
about what it says.
Great. Thank you very much. Okay, let's move on to the proposed amendment of the convention center fees. Parker, I think that's yours, right?
Yes, ma'am.
Good.
So this one, just to explain, so there is a state statute which allows us to impose upon lodging facilities a convention center fee for beds that they rent out, or for temporary lodging, really. And so the proceeds from that convention center fee can be used for constructing, managing convention center, or paying the bond that built it, whatever convention center fees you may have. When this was originally passed, it gave an exemption from lodgings that were greater than 30 days, much like lodger's tax, which we discussed a little while ago. But in this case, almost immediately after, a year after it was originally passed, it was amended in the state statute to decrease that exemption from 30 days to 15 days. We did not change our ordinance to match that. So in our section, Article 3 of Chapter 23 of the Roswell City Code, which is where we actually enact that convention center fee, which is permitted in state statute, we still have the exemption at 30 days. We never reduced it down to 15. So this ordinance would just fix that to match state statutes. Very straightforward. There's the section that we're talking about there, and you can see that's exactly what we're doing. We're just crossing out 30 and putting in 15. I would also point out, while we're here, subsection 2 there does not make sense to me. If the convention center fee shall not apply if the local government entity by ordinance exempts lodging facilities whose maximum daily room charge is less than an amount stated in the ordinance. That looks to me like it was copied and pasted out of the state statute without really thinking about what it was saying, because what that's saying is if we want to create an exemption by ordinance for properties that have a maximum daily charge of less than a certain amount that we decide, we could do that. But we haven't done that. We've just copied and pasted the instruction out of the statute into our ordinance, which does not make sense. So I could suggest that, and you could just strike that subsection completely and it would make a lot more sense. Just a thought.
Okay. Any questions? Tell me again which you're talking about. You're talking about
So-
exemptions, sub 2?
Right, number 2. So the convention center fee shall not apply, subsection 2, if the local government entity by ordinance exempts lodging facilities whose maximum daily room charge is less than the amount stated in the ordinance.
We don't have a,
We don't do that.
state it.
What they've
Okay.
done there is copied and pasted it out of the state statute.
This is meant for crew business. They use daily rate. They don't stay overnight at big airports.
Could you say
Yeah,
that
so once you get it.
at a
I don't think
microphone,
we got it on
please,
that.
so we could?
Hi, this is meant for crew business at airports where they have a daily rate and they don't stay overnight.
So does that apply to Roswell?
No.
No.
It doesn't.
And we would, and even if, I mean, I think if we wanted to, we could, again, we could set something, but just copying that out of the ordinance, or out of the state statute doesn't make any sense. We should set something by ordinance if we want to, not write, we can do it. That, I don't know why we would do that. So,
Go ahead, Councilor Foster.
Well, I have a question on another section of it, so that's what.
Okay, let's talk about this right now. How do we, Councilor Perry?
no,
Oh, you were preparing.
No, if there's not an issue, I mean, what's being discussed about the airport situation is striking two going to make any difference whatsoever? And so I'm okay with it being removed. I yield.
I'm okay with it being removed too, but my questioning comes to 7. Well, so
Okay, let's take care of 2 first.
let's
Or
take
just
care of
delete?
2.
Okay. Is there any opposition to deleting number 2? Under section 23-73, exemptions. Okay, let's take it as if that one is deleted right now, then there's renumbering. And then Councillor Foster, which one are you referring to?
On 7, has the latest change in lodger's tax law changed this one too? Because it says, I mean, lodger's tax used to be that it didn't apply to vendors that did not offer at least 3 rooms. Now it does. And so now this one should fall under that too, or
They
it
did
doesn't?
not do that.
They did not change it?
changed lodger's tax, but this is a separate statute, and although the wording is the same,
Yeah.
they changed the one, but they left the other as is. So this is still state law about the 3 rooms,
Okay,
so.
all right.
Okay, so we leave the current number 7 alone. Any other questions or concerns, discussion?
Madam Chair, I make a motion that we send to full council for the September agenda, regular agenda, to be placed, that the draft ordinance updating section 27-73 of the Roswell City Code relating to exemptions from fees for convention center financing be sent as presented with the removal of section 23-73 subsection 2 being removed, and then 3, 4, 5, 6, 7 all be moved up in correct numerical order for advertisement for public hearing.
Okay, we have a
Second.
motion, and we have a second. Is there any further discussion on the ordinance amending convention center fees along with the changes made today? Okay, hearing none, all those in favor of the motion, please signify by saying aye. Aye. Opposed, no. The ayes have it. That will go to full council with our recommendation. Next on the agenda is the ordinance, RFP 21-001, which is event management services scope of work. We have, okay, Stephanie, I've got it. Let me give you, okay. Thank you. That's, yeah, thank you. Okay, Stephanie, do you want to start?
Afternoon, Madam Chair, members. I'm here today to present the scope of work for the RFP 21-001, which is the event management services option for our core annual event, the UFO Festival. I'd like to share a little background of how we got here. The UFO event was initially created by the city of Roswell. Sorry. There we go. In 2014, the city outsourced the event. The organization did an MOU, and most recently, the city provided approximately $40,000 to Main Street Roswell with additional costs to the city. Main Street Roswell elected not to take on the responsibility and organizing of the UFO Festival for next year. And due to COVID-19, we had the opportunity to reevaluate the future of the event. We have a few goals in mind to look at options, and this is one of those options. We could include a citywide platform with multiple layers of entertainment, activities options with the goal to elevate the Roswell brand and increase the attendees' experience. We have a tourism vision, which includes driving the destination economic impact, job creation, community sustainability, and quality of life for our citizens. We've listed a few of the goals below, and if anyone has any questions. I'll explain a little bit of how destination promotion drives economic development through destination. There you go. It's meant to attract the prospects that drive economic development and agencies. Not only do these events create valuable exposure among business decision makers, they create direct opportunities for economic development agencies to deepen connections with attendees. We also put together a comparison with option A and option B. Option A is the local municipality pros, which include the low cost, a sense of inclusion, control of the process, rebuild with vision, strategic measures, and a citywide festival. Some of the cons will include events will always be the same size, drama, local political pressures between event organizers and volunteers. Currently, we are not built to staff or execute the organization. Option B includes professional event company pros, which takes your event from local hands and puts it in the national spotlight. The time and energy to produce a well-planned destination event are simply beyond the scope and experience level of a local organization. Events will experience continuous measured growth. Promotion and execution will bring more people on a national level and a larger economic impact to the business around Roswell. There are also a few cons. The initial investment in the event planning company and the loss of control for day-to-day. Any questions on that?
I guess not.
Importantly is the lodger's tax and hometown events. Hometown events are defined by a percentage of local attendees or a short-term 3-hour range versus the out-of-town guests staying in hotels. We evaluated the lodger's tax awards in 2019 and we funded $115,359. Room nights generated $19,700 in lodger's tax. I believe that we feel that hometown events are important and valued in our community. They serve an important opportunity to drive local businesses, develop partnerships, and generate hometown pride. The next slide shows our comparison and how we got there. We looked at all the events for 2019. I looked at how many rooms they picked up, how much award money they received, and what the impact was. Lodger's tax revenue and rewards. Lodger's tax revenue is a result of hotel overnight stays only. The use of revenue is strictly outlined in New Mexico state statute. The purpose to use the reward for tourism-related expenses that drive additional overnight stays. The benefits gained drive the destination, the economy, the job creation, community sustainability, and the quality of life for citizens. As hotels improve, they hire workers spend money, that lifts up our community and it develops the growth. I'm just going to go over briefly the overarching scope of work. There's several pages, but the overarching is that the City of Roswell's core annual UFO event is meant to represent the destination as a whole, to promote and drive tourism economic development. For task 1, it will be to evaluate historical data, create a design to elevate the UFO experience and event, with several other tasks listed. Next would be to outline all event logistics with the timeline, and that goes through several on the next few pages. I'm on page 13 now. The last task would be a proposal and budget recommendations. The city intends to award a contract, if this moves forward, to an event management service for a 1-year period, with the option to renew for additional years in 1-year increments. Our staff recommendation is for the City of Roswell's core event, which is the UFO Festival, to consider the scope of work for RFP 21-001 for an event management service option for the City of Roswell. And I'll stand for any questions.
Okay, thank you. Appreciate the handout. Are there any questions at this point? Let me just say, because I don't know that you mentioned it, this would be using the 40,000 that's already in our budget that was budgeted for the event, so it's already in the budget. It's
Correct.
Okay.
Yes.
And let's see. Let me see if there are any other questions. I have. No.
Well, one of the questions, so it's gonna use the 40,000 for the, and we're gonna go out for RFP for an event coordinator to use that 40,000 to create this 3-day event, correct?
Correct. So we would go out to an RFP bid to, for an event management company. They would submit a proposal, budget recommendations, and come up with some things that we don't already do, like ticketed certain things, elevating it. So everybody's going to have different proposals, and it has to fit our needs. There are big ones, there are small ones, but that is the intent, is to elevate the festival and have more of an impact on lodgers tax, quite frankly.
Okay. And that being said, and I'm glad you ended with that one, because the one clarification I wanted to say is that, in looking at this, we spent 115,000, and I mean, and it looks like we're saying, and we only got $19,700 back from it. But that is not what we got back from it, because we don't show the, I mean, lodgers taxes is not a dollar for dollar getting back into the same bucket. We spend the lodgers tax as to prime the pump for the GRT that comes in to us because of those events. And that GRT is what the city's looking for. Lodgers tax, as defined, we can't use it for anything other than what's specific. And GRT we can use for everything that we need to use it for. And so that's what we, as a city, have always used the lodgers tax to prime the pump, to bring in the gross revenue taxes and bring in the people for that time. So I've never looked at it for that. It brings heads and beds, but it doesn't have to be a dollar for dollar. If we spend $100,000, we don't have to have $100,000 worth of beds being filled. Besides the fact, the argument I've always said is our UFO festival brings people 365 days a year. It doesn't bring it just for that 3-day event. And that's the 3-day event's what we measure. So it brings untold amount of money coming into us because of it. So, but I do like the presentation. I just don't want it, when people look at this, I don't want them to say, oh, we're saying that we wasted basically $97,000. We didn't, because that's what it's used for, to prime the pump.
Can I make a comment?
Sure.
And we were looking at as direct expense impact. There is indirect, they go out and they get the gas and buy something at the restaurant too.
And Madam Chair, members of the committee, I wanted to come up and just explain that where the budget, or the money is budgeted, it's 20,000 that was in the general fund is what we had given to Main Street, and then another 21,000, we rounded it to 40 from lodgers tax for this. We would not be able to use the lodgers tax to pay for the service. It would be from the general fund amount.
That would be the general fund. Thank you. Appreciate that. Okay, Mr. Peterson.
Thank you. Thanks for the presentation. Main Street Roswell has, they've done a great job the past few years. But I think this event needs us, and I'm going to support it 100%. Thank you.
Thank you.
Thank you. Councillor Perry, any comments?
I'm just trying to completely wrap myself around everything, and I apologize, I had to step out for a second, I had to.
Oh, I'm sorry.
So understanding, it says here in the background, the UFO event was initially created by the city of Roswell. Okay, I'm seeing now. In 2014, the city outsourced MOU for the management. The city provided an amount, okay. So financial consideration, $40,000 per year for the scope of work as outlined. This per year, so y'all are wanting us to approve something that would just continue year to year, or is this a one-time?
No.
For this purpose, it would be a one-time proposal with the option to renew. It's how we do, it was how we did the Main Street MOU for, that included this. It's pretty much how we do most of our contracts. And the other thing to consider is that in 2 years, we will have our 75th. And this again is considering whether or not we even can have a festival next year, but we still have to go through the planning process and consider that we want to plan and move forward that we can have one.
Okay. Let me, while you're looking through that, make a few comments. I really like in your overreaching scope of work where you say building a stronger strategic core event, because I think what you're saying, and we sort of touched on it, Councillor Peterson, I think, is that we want to have an event that people will walk away and tell other people about, so that they come, as we're saying, as Councillor Foster said, any of the 365 days during the year. So I really like the idea of that. I just have a few questions. I'm looking at your bullet points in your actual scope, and I guess I'm on the second page, which is page 48 of the whole packet. They're going to do contract negotiations at the very first bullet, but people will not be contracting with them. It'll be signed by the city. Is that right?
The intent there is that we are hoping that they will go out and seek sponsorships on a national level for this event,
Okay.
as well as entertainment with a ticket sharing option where the city would get a percentage of whatever is negotiated between those two entities. They're just going to cut us a check. That is what we are looking for. We don't want to get involved in a lot of the procurement part of it. We're hiring them, they go and do it, they're just going to cut us a check for the work that they're doing.
And some of the professional organizations have multiple cities that they work with, entertainment or sponsorship.
Sure,
And
they've
we
got-
could benefit
Right.
from them working in other locations, and that could help.
I understand that, but I guess my question is, if they're going to be doing contract negotiations, who signs the contract?
They do.
They do. So what you're telling me, I think, is that for $40,000, we will have an event that they will, like you say, pretty much procure the pieces of it. Who makes the benefit or gets the benefit from it? They do then?
In the contract, should this go forward, we will have stipulations as to what we would get. So for example, in a perfect world, I would want 50% of all sponsorship dollars.
Okay.
I would want 50% of all vendors that are going to be sold. I would want at least, 80% of ticket sales. I'm kidding. I don't think we would get that, but
I know.
there would be some benefit to the city for allowing this company to utilize our brand, to utilize this platform, to also make revenue. They're going to be doing a lot of the work for a very minimal amount of dollars, and so we want to have it built as a cost-sharing model, but a benefit to the city.
Does something like that need to be in this scope of work? I mean, I understand that it'll be one of those that the city manager negotiates with the highest, whatever that is. But it just seems, I mean, the way I read this, but maybe I'm too novice at this, is that, I'm unclear that there could be a profit sharing or, some compensation, and that I'm assuming the city would still have, do a lot of our in-kind that we do for an event
Potentially.
of this magnitude, right?
Potentially, yes. But
Okay.
depending on who bids, they could be 100% self-sufficient and just bring in their people. As we were doing research, there's a lot of event management service companies that this is what they do for a living. And they
Right.
basically just travel from, they have trailers, they unpack the trailer, offload all of the equipment, materials, things like that,
Okay.
and just do it. Some, I think, locations, they will plant somebody within the community for a certain period of time. The other thing that would be part of this, that I don't think we've mentioned, is that we will also have community stakeholder roundtables built into the proposal.
What? I'm sorry.
Like a subcommittee to get
that's-
buy-in and feedback from the community members as to
Okay.
what they would like to see. Part of this, Stephanie and I, we have met with our previous partners, Main Street, as well as the UFO Museum and Research Center. We wanted to hear what their thoughts are. Do they want us to go to RFP? Would they want us to take it on internally? And we wanted to make sure that they also had a voice in what would be developed or presented to you guys. And so we also felt it's important for our community to have some say of what they would like to see
Good.
with this event.
Okay.
We
Because
would
one of
also
the.
own the data too. So the event management company would do all of the collections and surveys, but we would own the data.
Okay, okay. Because I actually kind of added a bullet that said something like, provide evaluations of the event to the city.
That's the historical data, yeah.
Okay, okay. And then, will this then be put into the typical format of an RFP?
Yes.
Okay. All right. Any other questions, Councilor Perry?
Thank you, Madam Chair. Just a few, for clarification. Through your research, do you feel like you're going to get many bites, if you would, on the 40,000 bait?
Most definitely during a COVID year, yes.
Okay, so that's question number one. Question number two, we're giving 40K. Is this coming out of general budget? Is this coming out of lodgers? And maybe I missed that portion while I was away.
Yes. So it will be coming out of the general fund, what's currently already had been budgeted. It's the same amount that was provided to the Main Street organization. 20,000 came from the general fund under the special event, and then 20,000 from lodgers. The lodgers tax piece was specific to advertising and marketing, so we would need to discuss that in part of their cost proposal that they would submit in the RFP.
Okay, so with that being said, do we expect to see something coming back later to us asking for money out of lodgers to?
Potentially, depending on what proposals we receive. We would like to see what the bidders are going to present to us based on this budget limit. And if they wanted to do more, then maybe we would. If there was something reasonable in their cost proposal, like ticket sharing or things like that, that we thought would be more cost sharing and a benefit to the city, then maybe not.
I just want there to be recognition. The elephant in the room is that we can approve this and still be left with nothing at the end of the day if council does not approve a further payment from lodgers or whatever.
So right now, what we're asked to make a recommendation to council on is actually the language in the RFP, scope of work.
The scope of work.
So it'll be, I guess, like any agreement like, or RFP like this, it's up to the city manager to negotiate with the highest bidder. Go ahead, Councilor Foster.
That, when you said in a year of COVID, it reminded me, and it's a question for Parker. Okay, with the 20,000 coming out of lodgers tax, I mean, we could possibly retain services of somebody and realize, and never have the option of having this event.
I would hope that would be part of the negotiation.
Well, but my question is, could we even spend lodger's tax if it got down to the point where we didn't have the event?
That's where I was saying that the lodger's tax portion that was secured is for marketing and advertising. We could not use it to pay for this company.
Right. And so as long as, even if we went to the point we started advertising, even if we ended up having to pull back and say no, then we're still okay onto the spending that, because it's still on promotional. That was the concept that it was
And
hitting
it's,
me.
It's similar to kind of what happened this year with our 4th of July festival. So we had already given a deposit on our entertainer. We had already given a deposit on our laser, our light show, I think, or contracts had been signed. And there was something in one contract, but not in the other. And Parker was able to discuss and negotiate that services really were never rendered because they didn't perform the event.
And we didn't have to pay any of the deposits. So we
Got the
intend to
money
put
back.
that in language for next year. We've learned that lesson.
All right, well, that was my question.
Thank you. Any other comments or questions? So it does say that the city intends to award this contract for 1 year period with the option to renew for additional years in 1-year increments. So the option's there. Okay, any further discussion? Can I hear a motion on RFP 21-001, Event Management Services Scope of Work?
Madam Chair, I'd like to make a motion that we move forward with a recommendation to full city council to approving the RFP 21-001 Event Management Services Scope of Work to be placed on the September consent agenda.
Okay, a second? We have a second. Any further discussion? Okay, hearing none, all those in favor, please signify by saying aye.
Aye.
Opposed, no. Motion carries then. This will go to council with our recommendation. Thank you both.
Thank you.
Sounds like an exciting turn in events. Okay, next on our agenda is the RFP 21-002 Ambulance Services Scope of Work. Is there someone here to talk on it?
This came out of the fire department, but I don't believe we have anyone from the fire department here tonight. I can introduce it, though.
Well, let me just stop you then. If that's the case, Scott's been waiting a long time. I think I'm going to use chairman's priority of, or I don't know what it is, chairman's whatever. I don't mean priority. Privilege. Chairman's privilege of moving item ITB 21-002 ahead of the RFP, if that's okay.
Very good.
Okay, thank you. Okay,
First, I'll say thank you.
of course.
So, this particular ITB is for a rehabilitation of taxiways Alpha, partial Alpha, and all of taxiway Juliet. If you want to look back at the map that was in the previous one on page 8, it is at the north end of the airport, right next to Dean Baldwin, between the Dean Baldwin hangar and runway 17. The two taxiways that connect to the runway 17 is what we're talking about. So on August 6th, we opened the bids for this ITB, and J&H Services was the low bidder, but was not completely responsive in that they did not have all of the sheets that were required for the bid. So we are requesting to award to Constructors, Inc., which was the second bidder. And happy to answer any questions.
Okay. I'm sorry, I can't even find it, because I'm looking.
Page 58.
Thank you, sir. 58, thank you.
Yeah, 57, 58, and a couple past that.
Okay, thank you. You know, if I have to wear this mask forever, I'm not gonna be able to, do- you know, I have to figure out another way to flip my pages.
I'm crippled when I'm trying to turn the pages anymore.
Okay, so, I'm sorry, are there any questions as to Mr. Stark's presentation? I think it's pretty cut and dried. They met, wait, I was going to say, you've got a sheet back here.
Yeah, the tab sheets are on the back of the package.
Page 61 of the packet.
58 is where the award recommendation letter starts. So 58 and 59 are that letter through 60, and then page 61 is the bid tabulations.
Right, okay, that's what I was sort of looking at, so there's the comparison.
Yeah.
All right, are there any questions or comments about this awarding? Can I get a motion?
Madam Chair, I make a motion that we send to full council for the September agenda to the consent agenda, the award of ITB 21-002 improvements to RAC Taxiway, to A&J Constructors Incorporated.
No, it's to Constructors, Inc.
Yeah, it's Constructors, Inc.
I'm sorry.
Constructors, Inc., yeah, I'm sorry, too.
I think they misspelled it on there. They wrote Construction, Inc. It's Constructors, Inc.
Oh, it says
Oh,
A and J to
taxiway,
Constructors,
A and
Inc.
J,
Yeah,
two.
taxis A
I'm
and
sorry.
J, that's what it is.
Yes, Constructors, Inc. I'm sorry, I'm reading it all incorrectly. So let me just rephrase that. Thank you, Councilor Foster, for catching that. Improvements to the RSC taxiways A and J to Constructors, Inc.
Second.
Okay, we have a motion and a second to send to full council. I think this is on the consent agenda. The awarding of ITB 21-002. Any comments or questions? All those in favor, please signify by saying aye.
Aye.
All opposed, no. Motion carries. That'll be on the consent agenda for September. Thank you.
Thank you.
Okay, now let's go back up to item 5, RFP 21-002, ambulance services scope of work. And I forgot if the records could reflect that Councilor Peterson left, I think at
5:59.
59, well, I put 6 o'clock, so, okay, 5:59. All right, who's presenting this? Is it you, Parker?
By default.
By default, yes,
Yes.
sorry.
So we do contract out to a independent contractor for all of our ambulance services for the city. Right now, that contractor is Superior Ambulance. By the procurement code, we must take this back out to a RFP. That contract is coming to an end on its own terms, and we cannot renew it. So therefore, we must go back to RFP. And so this would be the scope of services. I believe it's basically, it's the same as the last one we did back in 2016. I guess I'll stand for any questions if I can answer them.
Thank you. Let me just say, on the, I guess, the first actual page, the introduction of the draft scope of work, which is on page 51, I'm concerned about the dates in here, and I'm assuming that may reflect on the total numbers. So in the second paragraph of the introduction, very last line, it says the contract expires on June 30th of, now I've written over it, is it 16?
2016.
It should be 2020 is when, and so right now we've got a interim agreement that we're hobbling along on, but we have to go out to RFP.
Okay, so it did expire, but we have an interim, but that number should be,
2020.
and I'm not sure if it's even June 30th because of the interim, so you may, if you've got some interims going, if this is, I mean, I don't know.
Right,
So
right.
you might just look at that whole date.
Yes.
Parker, if you don't mind. Now in that third paragraph, next to the last line, the sentence starts during calendar year 2015,
Yes.
which causes me to question if these figures are correct as to the latest year.
I believe that they are reflective of 2015. And this is something that,
Oh, here's Mr. Matthews. Sorry, Mike, appreciate you coming. No, it's okay, you're not actually.
I'm not
Do
sure
you
where
have a
you're at in
cop-
the discussion. This request, Madam Chairman, Chair, members of the committee, this request is to authorize advertisement for the scope of work for the ambulance contract. Typically, we put it out at a 2-year contract with the option of either one or two 1-year extensions or 1 2-year extension. We've gone through that process. Contract has expired. We've been doing a month-to-month because of the COVID.
Right.
And we just need to get it back out, get it advertised, and see what providers are out there that would like to bid on the contract.
So, Mike, I was just having questions, and you don't have this in front of you.
I left it laying on my desk.
That's all right. In the draft scope of work, thank you, Councilor Foster. In the introduction page, I'm just questioning, at the end of that second paragraph, it does say it expires June 30th of 16. So that needs to be updated. And
That is a typo. I did review this entire thing a couple of days ago, and it's word for word verbatim for every year for the last, I think I
That's
went
what I
back to
figured, but-
2002.
Oh,
And
really?
we've used this exact same format, exact same
Well,
verbiage.
then the
They just
dates
updated the numbers.
Okay.
So we will change that.
That, and then again in the next paragraph, next to the last line, during the calendar year 2015.
Right.
The service, and then I'm just curious about any of these numbers, if they actually are from 2019 or if they are from 2015.
I didn't verify the call numbers, but I will make sure that that's correct.
Yeah, because it could make a difference. So it would
Right.
be those listed there. And then also, in the second paragraph after that list where it says the Roswell Fire Department is a career fire department with different personnel. I'm just
That's correct.
curious if those are current numbers.
Those are correct.
Okay, so you know that better than I. And then on the next page, which primary responsibilities, I'm just curious again if these are all current and if the same procedure on the CCEMSA board, I'm looking at number L specifically, if those are all still
They are
current.
correct. They are
Okay.
correct.
Okay. And then on Q, the top of the next page, you want the license level, what is it, a list of active employees and their licensure level on April 1st. That's still correct? So even though this is going out late, it would still be as of April
Right, because
1st.
they
That's
have
when
till the end of the year to renew their licensing. And then by the time the state gets all that information in the database, by April, they should be able to pull to see what everybody's license levels are.
Okay, so April 1st is
Yeah,
still.
that's correct.
Then relevant issues, very next to the last line in that first paragraph. AAOC is comprised of the following members: Roswell City Council Fire Committee member.
Public Safety Committee member.
Okay, so you'll fix that. And then I like I say, the rest of it was just because of those dates, I was curious if the rest of this needed updating.
Yeah.
So, okay, thank you.
Mhm.
Anyone else have any questions about this?
I'm just impressed
With what?
catching these things.
I'm a catch kind of person.
The other, I do have a question, though.
Certainly.
Because coming from the Public Safety Committee, I also you may be aware, the fire department has been pursuing bringing the ambulance under their own, and I know we've had quite a few changes and things happen in our fire department, but where are we to date with the ability, or are we still pursuing that to bring the ambulance service under our own in-house?
Right now, there's some discussions about the first right of refusal and licensing. I know the EMS division chief has been working with the PRC to try to get, because we currently, at this time, we lease our certificate of necessity to Superior Ambulance. That we do own one ambulance now that we're trying to get it to, and work with the PRC on the licensing. How would that work with a shared license that the current provider could have the first right of refusal? If they were unable to do, say, out-of-state or out-of-town transfer, then we would be the next one. If we had personnel available, that we could potentially take that and kind of speed up the process a little more than waiting for a Elite or something like that from Carlsbad or someone from Albuquerque to come down here, to try to start slowly implementing into the system our personnel. Obviously, it goes back to, do I believe that our personnel could do a great job running the service? Absolutely, but we still struggle with becoming fully staffed. So I cannot in good conscience sit here before you today and tell you, yes, we need to take over the ambulance service when we're not fully staffed in the fire department. So we would probably be having a different conversation if that was the case. If we had every position filled and we were fully staffed and we had the paramedics and stuff on board, then we could have a different conversation, but we're not there, in my opinion.
All right. And to be clear on the PRC portion of it, our ambulance that we currently have can transport, we just cannot charge for those services. And so in a case of using it as a backup, we can do it, but we just cannot charge insurance purposes to do that. So it's good for us to have it, but what we're trying to get to the point where, and the case being that a lot of times our contract ambulance service, the past one, not the one we currently have, we're using their transports to transport out of state, and when it came time for citizens of Roswell to get transported, we didn't have ambulances available. And so that's what we got to make sure doesn't happen. But we do have, our fire department has taken it upon themselves to have an ambulance so that we can be a backup. We just can't charge for those services right now.
Thank you. Okay. Any other questions or comments? No.
Madam Chair, I'll make a motion that we send RFP 21-002 ambulance services scope of work to full council. Is this for consent or for regular agenda?
I imagine it's consent.
Okay, for the consent agenda for approval.
Second.
Okay, we have a motion and a second to send this to full council with a recommendation to approve. Any other discussion or comments? Hearing none, all those in favor, please signify by saying aye.
Aye.
Opposed, no. Motion carries. Thank you, Mr.
Thank
Matthews,
you.
for coming over. The only other thing we have included in our packet are the department reports from City Clerk, Legal, and Safety. Are there any questions or comments on any of those? I'm just going to say another time, I really appreciate having these in here. And I hope everybody's looking at other committees' reports from staff that they aren't specifically involved in. Okay, I don't have anything. Any other business comments? Okay, then the legal committee is adjourned at, pardon me? 6:14. Have a good evening, everybody.